Marc Ostrow is a copyright and entertainment attorney based in New York City. Marc, Sheeran says he and his collaborator independently wrote their song. When we're dealing with essential building blocks of music, what's the difference between creative inspiration and theft?
And there is no clear line. It's basically a continuum of things that are clearly not protectable under copyright. Typically, chord progressions, chord changes are considered basic building blocks. The blurred lines case said that you can't copyright a feel or a groove. As you have a commonality of more and more individually unprotectable elements and you combine them in a original fashion, that itself becomes protectable. So that's ultimately what this case is about. There's no denying that there are other songs that use the same building blocks, but it is the combination of those building blocks, how original that combination is between the two songs.
How strong is the plaintiff's claim here?
Is fairly strong because there is a large degree of commonality. However, the melody of the two songs is very different, and certainly none of the lyrics are in common. But what is in common is not only do you have nearly identical chord progression, but you have what's called the same harmonic rhythm. The rhythm of the pace at which the chords change is the same.
All right, I want to make a quick correction. The song is Thinking Out Loud, not Shape of You. Sheeran had a case like this. He's won. He's had another that he's settled. And that's just him in the past few years. Have we seen an increase in these cases? And if so, why is that?
I think it all stems from the blurred lines case. When Robin Thicke and Pharrell were sued by the gay family, who aren't suing over this song, and the fact that they won a huge jury verdict. And again, the similarities between the two songs were about the overall feel and groove. Nowhere in the court's opinion could you point to specifics of the melody line, certainly not the lyrics, but it was to a certain degree kind of the backing track, the overall feel and groove. So when you go to that level, that opens a certain amount of floodgates to these kinds of lawsuits. But we have seen the tide turning back in recent times, because while the plaintiffs in the blurred lines case won, similar cases involving Led Zeppelin's Stairway to Heaven, the band won in that case, and Katy Perry won a case that was held up on appeal last year. So more cases are being filed, but you haven't seen that many plaintiffs succeeding.
After winning another copyright case back in 2022, Sheeran told the BBC that he started taping his sessions. You know, if you're coming to court with taped sessions, how great a defense is that? It
depends upon what is on the tape of those sessions. If it does show the actual songwriting and recording process, and those tapes show that the defendant isn't using the plaintiff's song, that is some indication. It's hard to say how valuable that is. Ultimately, the jury's going to listen to the two songs and make a determination based on the judge's instructions.
All right, Marc Ostrow is a copyright and entertainment attorney. Marc, we appreciate your time and insight and your musical abilities tonight.
Thank you. It was a pleasure being here.